Good afternoon. I have with me Mr. Lawson Naidoo of CASAC. Now, the Constitutional Court has issued directions that former President Jacob Zuma must file an affidavit addressing what penalty the court should impose if it were to find Mr. Zuma in contempt of court. But there's another case as well. Over the weekend, we learned that Judge President Lopez was found guilty of gross misconduct, but the fact is that he is still staying on in his position. These two incidents are raising questions, and to discuss these questions, I'm talking to Lawson Naidoo. Lawson, let's start with Mr. Zuma's case. Judge President Mogoeng Mogoeng sending out sort of a request to Mr. Zuma, asking him what penalty he should get. Some say that's how it should be done in the law, but others don't agree. What do you think is happening here?
Thank you very much for the opportunity. In the case of the action that has been taken by the Constitutional Court to issue the set of directions to the parties in the matter, it's not unusual for the court to issue directions to a party, even after a matter has been heard, to ask for further information. This, however, is quite a unique set of circumstances because the Constitutional Court is hearing this contempt of court matter as the court of first and last instance. Secondly, the fact that Mr. Zuma did not participate in the proceedings of the Constitutional Court. So I think the reasoning behind why the Constitutional Court has taken this unusual step to ask for submissions from Mr. Zuma on what an appropriate penalty should be were he to be found guilty of contempt of court. It is unusual, but I think the court wants to ensure that Mr. Zuma is given every opportunity to address the issues that the court has to adjudicate upon. So the court will obviously not be bound by what Mr. Zuma might say, although on the other hand, it's also quite unlikely that Mr. Zuma will respond in any event.
Coming to say that, yes. Mr. Lawson, can you also, there are people that say, but this is treating someone different than the rest, and that it means that we are not all equal. Can you?
I hear that criticism, and I think it's a valid criticism at some levels. But as I say, this is an exceptional case in exceptional circumstances where the Constitutional Court is hearing the matter as a court of first and last instance. There's no appeal from this court, and it wants to be making sure that it does the right thing. This, I think, will be the very first time that the Constitutional Court will be imposing a custodial sentence on someone. In the past, they will have confirmed convictions and sentences that were set by other courts. But this is the first time that the Constitutional Court, if they decide to do so, is going to send someone to jail. So these are unusual circumstances. This is an unusual set of directions. Normally, one calls for arguments in mitigation of sentence or in aggravation of sentence by prosecution after a conviction has been declared by a court. The court will then, after they found someone guilty, hear those arguments. So here the court is doing it in a slightly different order. But to that extent, it's the process that's a little bit unusual, but not the substance of what is being asked for.
Let alone sending someone to jail, it's the first time it's a president that stands the chance to go to jail. So that makes it totally different, I suppose.
Indeed, it does.
Lawson, there's also the criticism that this is affecting the judiciary in a negative way, and that we should be worried about the judiciary. Your comments on that?
No, I don't agree with those sentiments that are being expressed. I don't think there's much to worry about in our judiciary. I think there are certain things where we can strengthen aspects of the functioning of the courts and the judiciary as a whole. but these are issues that are being engaged with on an ongoing basis. I think those that are seeking to undermine the independence of the judiciary and to place the judiciary at the center of our political debates is wrong. It undermines the judiciary. Political agenda behind people who are making those points, and they do so to try and deliberately undermine the judiciary, because the reality is that in the aftermath of state capture now, many of those former high-ranking political officials are now going to face the might of the law in the very courts, and they want to undermine the integrity of the court so that they can argue that they did not perhaps get a fair trial and so on. So this is nothing to do with the issues within the judiciary as such, but more an issue of politics playing out and using the judiciary as a football.
Let's go to the other case that are worrying people, and that is of Judge President Lopez. It was found that he is guilty of gross misconduct after years of investigation. But the problem is, according to people, that he still stays on in his position. One should think that a judge at least should stand aside immediately when found guilty of something like that, let alone just putting that against him.
Well, I think we need to understand the provisions of the Constitution and the law in this regard. It is only the president that can suspend a judge from duty, and the president can only do that in terms of a recommendation from the Judicial Services Commission to that effect. Now, the JSC had the opportunity when it took the decision some time ago to refer this complaint against Judge Lopez to the Judicial Conduct Tribunal. At that point, it had the responsibility to inform the president of the steps that it was taking, and simultaneously, they could have recommended to the president that he suspend the judge president whilst this process unfolded. They did not do so at the time. They did not do so again when a further matter relating to the alleged assault of a member of the High Court against Judge Lopez was also been referred to a tribunal. But now that there is an actual finding of gross misconduct by the Judicial Conduct Tribunal, I think it's compelling for the JSC to apply its mind once again to the fitness of Judge Lopez to continue to serve on the bench whilst the JSC considers the tribunal decision and perhaps refers the matter to Parliament. So I think the time is now ripe that Judge President Lopez should be placed on suspension whilst these processes continue.
So in both these cases, there's no reason to be worried about the integrity of the judiciary.
No, I don't think there is. I mean, of course, in the case of the matter involving Judge Lopez, what is of concern is that it has taken us 13 years since the infringement occurred, since he attempted to influence the two judges of the Constitutional Court, which was way back in 2008. The fact that the matter is only being resolved 13 years later in 2021, that is the issue of concern. But we also know that the processes of the JSC have changed over the years, and they are now somewhat, more rationalized and quicker. But there's still a long way to go for the JSC in being able to expedite complaints that they receive against members of the judiciary. And I think it's important that these matters get dealt with as speedily as possible to preserve the very integrity of the judiciary, so we don't have clouds hanging over judges for 13 years like we have had in this case, and for almost 10 years in the case of Judge Motata.
Lawson Naidoo of CASAC, thank you very much for your time. I appreciate it.
Thank you.
Keep well.